Hey class, Mr. Stewart here. This is going to be the integrity video for week 3 of the fall term, and this is going to be covering chapter 4 in your text. So you're tasked with reading chapter 4 this week. I'm not going to spend a lot of time on this, but I just want to try to clear some of the mud, if you will, in regard to direct and circumstantial evidence, as well as the use of inferences as evidence in a case. So again, there's no substitution for you reading these chapters. You really shouldn't just listen to what I say and participate in the discussion boards only. You should be reading the chapters every single week. So if you have not received or bought your textbook yet, you need to buy the book. And if you are having financial issues and you cannot get the most current edition, the 8th edition would suffice. But you need to have a textbook here. You need to be reading this book. Simply because if we were in a brick and mortar classroom, you would have the benefit of me being able to spend 2.5 hours every single week going through and explaining some of the stuff that's in the book in much greater detail. However, in an online class, you don't have that luxury, so you get me for a few minutes every week on these integrity videos if they work for you, and which I can't promise that they'll work, but because we've been having some major issues with integrity. But again, there's just no substitute for reading. So this week we're going to be talking about direct and circumstantial evidence and the use of inference. In inference is different than deduction, which uses logic. Inference is kind of some conclusions that are drawn based upon the facts at hand, and it's a little bit subjective to a certain degree. So just understand that some inferences are okay to be used and some are not, and we'll talk a little bit about that. But the first thing I want to talk about is go through your learning objectives here. And we've already talked, and you've already read a little bit about who has the burden of proof in a criminal case here in the United States, and that is the prosecution. And that burden of proof actually has two components. The burden of proof, first component is the burden of production, and that requires the party with the burden on the factual issue to introduce sufficient relevant evidence to prove the fact at issue, which means they have to produce enough evidence to prove that defendant guilty. And then they have the burden of persuasion, which also sets on the prosecution, that says that the party with the burden to produce sufficient evidence persuade the fact finder that a fact exists. So not only do you have to have the evidence, relevant evidence, but it has to be able to persuade the judge or the jury, depending upon the type of trial that it is, that that piece of evidence does go towards proving guilt. So that's what the burden of proof is. The defense has nothing to prove here in the United States. They don't have to put on any evidence. They have to prove nothing. If the prosecution doesn't sufficiently prove guilt beyond that reasonable doubt, then the jury should find that defendant not guilty. However, the defense does usually put on some evidence to try to impeach or discredit whatever the evidence that the prosecution has, or the witnesses or the testimony that those witnesses are providing. Hopefully that makes sense to you. So in order to convict the defendant, every essential element of the crime must be proved by the prosecution beyond a reasonable doubt. What is the definition of a reasonable doubt? Well, if you were to put the same set of facts and circumstances before any Tom, Dick, or Harry out there on the street, and they would likely come to the same conclusion as you, then that's the definition of reasonableness. And basically, you have to prove that guilt beyond a reasonable doubt, which means you got to be probably better than 90% sure and be able to prove it in a court that the defendant did engage in the crime before they can indeed be found guilty of that. So Sandoval versus California is a court case. Make sure you read over that in the textbook here. It talks about the reasonable doubt standard, and there's quite a bit of information about reasonable doubt in the first part of this chapter in your text. And it's really straightforward. You just need to read over it and try to get it in your mind. Okay, I want to move on here and talk about direct and circumstantial evidence. So the U.S. Constitution requires that in all criminal cases, the state or federal government prove the essential elements of a crime beyond a reasonable doubt using two types of evidence. And I'm going to talk about direct evidence first, because that's the one that makes sense to most people. Direct evidence is exactly that. It is something that proves or disproves a fact and issue without any reasoning or inferences. It speaks for itself. It either directly proves or it directly disproves something on its face. It doesn't require any reasoning. It doesn't require any inferences to be drawn. It speaks for itself. For example, a piece of direct evidence in a murder case in which someone was stabbed to death would be the knife that was removed from the dead victim by the medical examiner, along with evidence to show where that knife had entered the body and what organs that it had pierced and caused to fail. That would be a piece of direct evidence. It stands alone. However, maybe who wielded that knife might fall under circumstantial evidence. If nobody saw who stabbed that person, but yet you had a witness see someone leave the immediate area of where the crime occurred just prior to the police getting called and arriving, then that could be circumstantial evidence. You could logically draw some inferences, if you will, that person who was at the scene at least knew something about the crime. Maybe they were present during the crime, and potentially they were the perpetrator of the crime, simply because that was the only other person there other than the witness. And hopefully that makes sense to you. So circumstantial evidence is something that indirectly proves or disproves a fact and requires the fact finder to draw some inferences. And inferences is simply the ability to draw a conclusion based upon facts as they begin to mount or add up. So many people believe that you could never be convicted of a crime based on circumstantial evidence alone, and that is incorrect. You can be convicted of a crime. You can be sentenced to prison or potentially even the death penalty if you had a huge mountain of circumstantial evidence in which you could draw likely conclusions that this person did the crime, this person was there. There's nothing that directly links this person to the crime, but you have a whole lot of circumstantial evidence. You can get a conviction on that. However, the case would be made stronger by the existence of direct evidence, such as the fingerprints of the defendant on the bloody knife, and that's the only fingerprints that were on the knife that was removed from the dead person's body. That is a piece of direct evidence. It stands alone. There's no question that at least at some point that defendant held or gripped that knife. Now we may have to draw an inference that they stabbed, but if we can connect them directly to the weapon that caused the death, then it's again a logical inference to draw that they potentially were the one that caused the death. Along with, you would have some other circumstantial evidence that would lead you to that inference, but that's something that makes sense. You would be able to make that draw that conclusion, if you will. So how do we use evidence to prove a fact? This particular slide right here does a pretty good job of describing that. So this first box on the left says presentation in court of physical evidence, physical objects such as guns, knives, whatever, documents, papers, fingerprints, photographs, and or testimony of witnesses will lead you into sufficient, convincing, reliable, and competent evidence. If all of those things are sufficient, convincing, reliable, and competent, that can result in the proof of the fact or the establishment of the existence of a fact, which could in turn lead you lead the jury into the conviction. So, I think it's fairly clear what the difference between direct and circumstantial evidence is, and basically the rest of this chapter just kind of looks into some very specific things, inferences that should be drawn that are permissible, inferences that should not be drawn that are not permissible. This slide asks us to look at the inference of intent. If you remember, one of the elements of crime is to prove the mens rea, or the criminal intent of the defendant to engage in the behavior that resulted in the crime. So to prove intent, the law infers that people intend the reasonable, foreseeable consequences of their intentional and deliberate acts. So these inferences must flow rationally from the evidence presented in court. You can't jump over hills, if you will, to make inferences. Hang on one second. Okay, sorry about that. Somebody called, told me I left my lights on in my truck, so had to go turn those off. Alright, where we were, let me get back to the slide here. Okay, it's still talking about direct and circumstantial evidence. Direct evidence proves or disproves the fact without having to draw upon any reasoning or inferences, and again, circumstantial evidence indirectly proves or disproves the fact, and inferences must be made in order to use circumstantial evidence to prove or disprove the fact. And this just proves what I said a few minutes ago. In some cases, circumstantial evidence alone can be used. When only circumstantial evidence is used, many states do not follow a general rule, but add requirements. In a few crimes, such as treason, prosecutors use direct evidence in proving the offenses. And prosecutors would always love to have direct evidence instead of circumstantial, but sometimes all they have, or a large portion of their evidence, is circumstantial. And so we get into this issue in the trial of is this a reasonable inference that has been drawn from this evidence? And see, that's what the defense will use. They will try to say, this is not a reasonable inference that the prosecution is drawing from this piece of evidence. This evidence is circumstantial. It does not directly link my client to this crime. It's requiring you to jump through a hoop or jump over a hill, if you will, in order to make that linkage. And so what the defense will try to do is use the fact that an inference has been drawn to put that reasonable doubt in the minds of the jury. And that's completely okay. That's just the way our legal system works. We are that adversarial system, two sides competing for the legal truth, and it is a competition, if you will. All right, please read on in your text here about means, motive, opportunity, and how that fits into the circumstantial evidence concept. Make sure you know what means is, what the motive is, what opportunity is. And this is one in many cases that they try to understand the motive of the criminal, because in lots of states, conviction of a crime can require the proof of a motive. What did the defendant mean to do? What was their intention here? What was the reasoning behind them engaging in this act? For example, if you're trying to prove, that somebody burned their car in order to collect the insurance money from it, and therefore to commit insurance fraud, you have to have some evidence that would prove some reasoning why that was necessary in their mind. You have to prove that was what they intended to do, and that they intended to actually profit from it instead of simply, I guess, lose a vehicle or something like that. So there had to be some sort of profit which would equal the motive in that particular case. Defendants may also use circumstantial evidence in their defense. They may not have any direct evidence that proves them not guilty. Remember, they don't have to prove, but if you and I both know that if we were charged with a criminal offense, we would want to try to at least put on some kind of defense to prove that we didn't do it. And hopefully that would put that sufficient reasonable doubt in the minds of the jury. And if that's the case, we can use direct or circumstantial evidence in our own defense as well. And then, of course, the prosecution gets the chance to discredit or impeach that also. Read about modus operandi, or the method of working or operating. That's how that's used as commonly as an investigative tool to link crimes to suspects. That is sometimes going to be considered circumstantial evidence, because we're asking the jury to draw some inferences of guilt where other crimes can be tied to the defendant. Fingerprints and shoe prints as circumstantial evidence. It depends on where they are and what they're used for. That could be direct evidence, or it could be circumstantial evidence, just depending upon the situation. The jury may use a permissible inference to reach a conclusion, and the prosecution retains the duty to persuade the jury to make the inference as well. So, read over these slides. This again goes into some of the more specific things that are used as circumstantial evidence, such as a rape kit, inferences drawn from other bad acts or other convictions. For example, one of the things you see on TV a lot of times is that maybe we're looking at a suspect for a particular crime, and you can say maybe you're investigating a particularly violent homicide, and you develop a suspect, and you look, and the suspect has 3 convictions for especially aggravated assault in the past. And so you try to use that as other bad acts or other convictions to prove their motive, their mindset, or their method of operations, their MO, if you will, that, hey, the violence in this homicide that we believe this suspect engaged in is very similar to the violence for which they've been convicted of in the past. So therefore, we're asking the court to draw an inference to show a pattern here. And that may lead to a greater likelihood of conviction, or perhaps even more punishment if the conviction does occur. So just keep that in mind as well. Again, several court cases in this chapter need to get in your mind as well. Understand that some inferences should not be drawn, and these are what's considered impermissible inferences, such as when a defendant exercises their privilege against self-incrimination. So if a defendant chooses not to testify on their own behalf, the jury should not make or draw an inference that that person is guilty, and therefore they don't want to testify in order to be found out. That's their right. They don't have they don't have to testify unless they want to. Any of us that get arrested or charged with a criminal offense, we do not have to say anything on our own behalf. We're not required, and it should not be used against us. If the information is protected by a rape shield law, for example, if there's some law in place that prevents the jury from obtaining a particular piece of information, or a past bad act or bad fact or something like that, the jury should also not draw inferences that that person is guilty because the law is protecting them. Another impermissible inference includes the cessation of a signature crime after a suspect's arrest. The fact that the crime stopped, a crime wave may have come to an end after the arrest. You can't draw that inference to say that, well, the crime wave stopped after we got this guy in custody, so therefore he must be the guilty party. You can't do that. Seems like a logical conclusion, and it makes sense to us, but the court says, nope, you cannot do that. And then the PowerPoint in your text goes on and describes some of the examples when you can use direct and circumstantial evidence. It's really straightforward. You can read over that, such as in drug cases, searches, etc. Child pornography is a big thing right now. We hear about people going to jail left and right for that. In many cases, circumstantial evidence is what is being used to prove and get a conviction for possession or trafficking in child pornography. For example, we may not be able to prove that it was you sitting behind that computer viewing particular images or transmitting particular images, but we can say through circumstantial evidence that the computer was yours. It was bought by you at whatever store. The IP address for the internet service comes back to your name at your address, and at the date and the time that the images were being transmitted, it's been proven that none of your other family members were at home. So we don't have anything that directly links you to the crime, but we have a lot of circumstantial evidence that you could draw an inference from that would lead the jury to believe that, hey, it must have been you. It couldn't have been anybody else but you, so therefore you're going to get convicted. And that's a really good example of just the way circumstantial evidence can be used in general. Nothing that directly proves or disproves, but it leads you into drawing some inferences that make sense, some logical conclusions, if you will. All right. Some other cases there. You can read through those. Proving the corpus delicti, or the body of the crime, by direct or circumstantial evidence. In all criminal cases, the prosecutor must prove that a crime has been committed. That's the body of the crime, the corpus delicti, and that the defendant committed the offense. The corpus delicti is ordinarily proved by direct evidence, as when a victim or an eyewitness tells the police about the occurrence of a crime. The corpus delicti can be proved by physical evidence, such as in the case of a murder, the dead body with a knife in the chest. I already kind of used that example. So, as a general rule, the body of the crime, or the fact that a crime has been committed, must be established beyond a reasonable doubt. If they cannot establish that a crime was even committed beyond a reasonable doubt, then there really is no conceivable way that we could prove that somebody engaged in a crime, nor should we be able to obtain a conviction. So we have to prove, number one, that a crime has been committed beyond that reasonable doubt. And then we have to prove that the defendant is the one that did it. Alright. Other than that, I think that's about all I wanted to cover in this chapter in the integrity video. If you have questions, always feel free to send me a course message, text me, email me, or whatnot, and I'll be happy to answer those questions, and then we'll address some of those things in discussions as well. But read over the PowerPoints, listen to this video, read every discussion posting that's out there, and you will understand. Alright, if you have any questions, problems, or concerns, reach out, and I'll see you next time. Bye-bye.